This week, it is the litigation group who is up to do the webinar. And my name is Todd Cook. I am a member of the litigation group here at Beresford Booth. Now, interestingly, although it's a litigation group week, I am going to discuss with you a non-litigation based legal process. And that's actually not atypical. Most of what I do is represent parties in civil litigation in the courts in Washington State. But whenever we're representing a party, we're looking for the best and most efficient, most cost-effective ways to resolve their dispute. And oftentimes that is through a non-judicial, non-litigation process. So that's what I want to talk about today. And specifically, I want to talk about the benefits and the process for a non-judicial foreclosure in Washington State. Now, I think that everyone probably understands generally what a foreclosure is, but let's talk about it. A foreclosure is simply the process by which a secured creditor enforces its lien rights in real estate following a borrower's default of their payment obligations under a mortgage agreement. And in Washington State, there are two different types of foreclosures, and they're both driven by Washington law, by the statutes passed by the state of Washington. And there's a judicial process and a non-judicial process. So the judicial process, I'm not going to go over in depth, but essentially it is filing a lawsuit in the local superior court of the county where the property is located, and getting a judgment for the lien amount, and the court oversees a process of selling the property to generate funds to pay off the creditor. And then the non-judicial process happens completely outside of the court setting, and it is overseen by the trustee named in a creditor's deed of trust, and it results in a trustee sale overseen by that trustee. So I would like to focus first on the question of why you would choose a non-judicial foreclosure. And it gets back to what I said at the beginning. Although I'm a litigator, we're always looking for the best, most efficient, most cost-effective way to resolve a client's problem. And the non-judicial foreclosure can be a simple and efficient process that takes place outside the court system. If you've ever litigated, you will know that litigation moves slowly. The court systems move slowly, and a judicial foreclosure process is no different than a normal lawsuit. It's going to be hampered by all the things that make normal lawsuits move slowly, which also make normal lawsuits more expensive. So the non-judicial foreclosure process avoids all of the complication and expense associated with going through a court process. Now, I do want to give the caveat that if you fit into the group of people, creditors who can do a non-judicial foreclosure, there's still a possibility that you'll end up in court because under Washington law, the debtor and other lien holders have a right to try to seek court intervention to stop a trustee sale through the non-judicial process, which can ultimately lead to effectively your non-judicial foreclosure becoming a judicial foreclosure process. And the statute that allows those people to seek court intervention is on the screen, RCW 6124-130. The second issue goes to the same point of efficiency, and that is, the finality aspect. You get to a final resolution more quickly with a non-judicial foreclosure. Both foreclosures result in a sale process where the real property is sold to create proceeds that pay off pay off the mortgage. But in a judicial foreclosure process, the debtor who owns the home has a right to redeem the property that either runs 8 months or 12 months, depending on whether the creditor has waived their right to seek a deficiency judgment. So after a judicial foreclosure sale, there's a period of uncertainty, up to 12 months where you're uncertain whether that sale will be unwound through the redemption process. With a non-judicial foreclosure, the trustee sale ends the process, essentially, sells the property to a new owner, and there is no right of redemption for the borrower. So you can get to finality more quickly. Okay, so not everyone can do a non-judicial foreclosure. So I want to talk quickly about, when is the process available? Now, there is a code section or a statutory section, RCW 61-24-030, which spells out all of the requisites of a trustee's sale. And the trustee sale, is the final process in the non-judicial foreclosure. So to do a non-judicial foreclosure, you essentially have to meet these requisites of a trustee's sale. I'm not going to discuss all of them because there's a bunch of statutory requisites, but I want to highlight three. First off, just a deal breaker on whether you can do it or not is the mortgage is secured by a deed of trust on the real property, and that deed of trust has to have a power of sale provision which authorizes the trustee to go through the non-judicial foreclosure process and conduct a trustee sale. So if you don't have that in your deed of trust, you're not going to be able to go through the non-judicial foreclosure process. So when you're planning your deed of trust, you should include that provision if your goal is to do a non-judicial foreclosure, if necessary. Now, if you have that provision, you're on the right track, but you also have to have your deed of trust confirm in the deed of trust that the property is not used principally for agricultural purposes. And finally, creditors have various remedies at their disposal, but to go the non-judicial foreclosure process with a trustee sale, you can't have already sued and have an ongoing lawsuit to collect under the mortgage. So essentially, there has to be no pending lawsuit. And then, if you meet those three, there are some other requisites to a trustee sale. All of the statutory provisions for a non-judicial foreclosure process are fairly involved in lengthy statutes. So you really need to go over them in detail with your attorney or have an attorney who knows them well. But they're, going through every subsection is beyond the scope of today's presentation. So if you are able to take advantage of the non-judicial foreclosure process, I now want to talk about what that process is and start with an overview. First, every foreclosure starts with the unfortunate event of a borrower defaulting on a payment obligation. Now, no one wants that. Creditors would rather, be paid under the terms of their loan agreements, and certainly, borrowers would rather not defaulting and be able to keep their properties. But that is the requisite, the first thing that happens in basically every foreclosure process. After the default happens, to carry out a trustee sale, the statute provides several different notices that need to be given. They need to be given to the borrower and other interested parties, such as junior lien holders or other people. It could be other lenders. It could be other people with mechanics liens or things like that, materialmen's liens. But you have to give certain statutory notices. You have to publish those notices. And once you go through that process, which also has timing mechanisms to it, a trustee sale happens. And normally that trustee sale happens on the courthouse steps in the county where the property is located. There's a winning bidder, at that sale process is an auction process. And after the winner is declared, the trustee issues a deed to the purchaser, which is a trustee's deed. And then the sale proceeds are collected right then and there, and the statute dictates how they're paid out, how they're distributed. So let's look at this process in a little more detail. Now, after the default occurs, the first statutory process is to give a notice of default. This is a notice that is spelled out in the requisites of trustee sale statute. The contents of the notice of default are very specific, and they are set by RCW 61-24-030 subsection 8. I'm not going to go through all of the contents and ins and outs of what needs to be in the notice of default, but some key provisions are that the notice has to be given at least 30 days before a notice of trustee sale is then given. The notice of default needs to be mailed both by first class and certified or registered mail to the borrower, and the notice needs to be posted on the property in a conspicuous place so that the borrower clearly is on notice that this process is happening. Now, subsection 8 of the statute sets the basic contents. There are also additional things that need to be met with this notice of default for certain residential properties, and those are spelled out in RCW 61-24-030 subsection 7A, and we're not going to get into those, but the point is you got to comply with how the statute says the notice of default needs to be drafted. Now, the next step isn't a statutory step. It's not required, but it's, I would say, a best practice. And that is that the creditor or trustee will want to obtain a trustee sale guarantee. Now, that is essentially a title policy, a title insurance policy, where a title insurance company will issue a policy ensuring the title that will be obtained through the trustee's sale. It's different, a little bit different than a normal title policy, but just like a normal title policy, it may come with exceptions that need to be cleared, and the trustee may need to work through clearing those exceptions in the days leading up to the trustee sale. And that's why it's important as a best practice to get that going early in the process. The next step is two different notices that are both spelled out under RCW 61-24-040, and that's the notice of foreclosure and the notice of trustee sale. Now, the notice of trustee sale is delivered to the debtor, and it's recorded in the county at least 90 days before the sale. So that's the key. So this whole process is usually a 120-day process, 30 days for the notice of default, an additional 90 days for the notice of trustee sale. In addition to the statutory requirements of how you deliver it and how you record it in the county, there's also a requirement that the notice of trustee sale is published in a legal newspaper in the county where the property is located. And then at the same time as giving that notice of trustee sale, the trustee is also giving a notice of foreclosure. And that notice of foreclosure, also spelled out by the statute, explains to the debtor their right to reinstate the mortgage up to 11 days before the trustee's sale. And it will describe in detail the amounts that are necessary to be paid to exercise that right to reinstate. Now, after 11 days, once you get closer than 11 days to the date of the published trustee's sale, the right to reinstate the mortgage expires. And so if they're going to take advantage of that, they need to exercise that before the 11-day mark. Now, after giving the notice of trustee's sale and waiting the statutory 90-day period, giving all the notices required and publications and recordings, clearing all of your exceptions under the trustee sale guarantee. The next step is to cry the sale. And that just means that the trustee or the trustee's agent goes to the place of the sale that's set forth in the notice of trustee sale at the time set forth, and basically reads a script to anyone who shows up, explaining the sale process and what's going to happen. Now, the crying of the sale is typically conducted on the steps of the county courthouse in the county where the property is located on a Friday morning. Now, it's important for the trustee before conducting the sale to do a check of bankruptcy dockets, because if a bankruptcy is filed before the trustee's sale, an automatic stay will come into place under the federal bankruptcy rules, and going forward with a sale with knowledge of, going forward with a sale once there's a bankruptcy could violate the automatic stay. So you want to be vigilant in making sure you know the status of whether a bankruptcy has been filed. So in that script that the trustee is going to read when they're crying the sale, they're going to explain to those present what the opening bid will be, which is, typically set at whatever the creditor wants to credit bid, and the other bid procedures for how it's going to work. So one, normal procedure is that the bidders, will need to pay if you're the winning bidder, you will need to be able to pay, ready and willing and able to pay the winning bid amount right then and there in a certified check or bank check or some immediate funds that the trustee will know that, they're getting receipt of payment now. And as I already implied, the creditor can credit bid up to the outstanding amount of the loan. So if it's a $1 million loan, the creditor could bid $1 million just based on the outstanding loan amount. At the end of the sale process, which will happen right then and there on the steps of the courthouse, the trustee will declare and announce who the winning bidder is, and then the sale process concludes with the trustee issuing a trustee's deed to the winning bidder. The trustee's deed is similar to a bargain and sale deed, which is spelled out under the Washington statutes. And essentially, the trustee isn't giving the winning bidder the warranties that would normally be associated with a statutory warranty deed. And then with any conveyance of real property in Washington State, you also have to file a real estate excise tax affidavit. So this applies equally to any type of foreclosure, but a real estate excise tax does not apply to a foreclosure sale of real property by the trustee under the terms of a deed of trust, whether to the beneficiary listed on that deed or to a third party. So typically the seller pays the excise tax, and here the trustee is not going to be required to pay excise tax, but will still have to file an excise tax affidavit, identifying the exception under WAC 458-61A 208 subsection 3. And then once the whole process is wrapped up, RCW 61-24-080 explains how the proceeds of the trustee sale will be distributed. First, the sale proceeds will go to cover the expenses of the sale. Next, the proceeds will go to satisfy the obligation secured by the deed of trust, just meaning that they will pay off the mortgage, the lender's mortgage to the borrower. And finally, if there are surplus funds, if it's $1 million loan and the sale price is $1.2 million, the debtor, or excuse me, the lender doesn't get to keep the whole 1.2 million. Other people have a claim to that. So the surplus will be deposited with the clerk of the Superior Court for the county where the property is located. The statute spells out notices that need to be given to interested parties, including the debtor and junior lien holders. And then there can be motions practiced by the interested parties to determine who and how and in what amounts other interested parties are going to share in the surplus sale proceeds. Now, the flip side often happens as well, that the trustee sale does not generate proceeds in excess of the outstanding loan amount, but instead there's a deficiency that, let's say the loan is for $1 million, but the sale only nets $800,000. And at that point, the creditor can then seek a deficiency judgment against the guarantors on the loan. One thing to keep in mind, if you're a creditor and you have it in mind that you're going to seek a deficiency judgment after a foreclosure, after a non-judicial foreclosure and a trustee sale, if you are the winning bidder via a credit bid, you are only going to be able to seek a deficiency judgment above the fair value of the property. So let's use that $1 million hypothetical. Let's say that the loan is $1 million. The property is worth $900,000. That's the fair value of the property. No one else shows up at the sale, and you bid $500,000 as a credit bid. You would technically, as the creditor, be the winning bidder on a credit bid, but you wouldn't then be able to seek a $500,000 deficiency, because you've now acquired a property that's worth $900,000. So if you're going to seek a deficiency, you can only seek the deficiency for the amount of the debt that is above the fair value. So there, in that hypothetical, you could seek a $100,000 deficiency judgment from the guarantors. That is the process in a nutshell. To summarize, there's lots of benefits in the efficiency and cost of doing a foreclosure outside of the court system, which is a slow, burdensome, and expensive system to navigate. Finality can be reached more quickly because there's no right of redemption following a trustee sale, as there is for a judicial foreclosure sale. But there are a lot of statutory hoops that you have to jump through with all the notices that you have to give. You have to follow the statute. So if you're doing this, you definitely need an attorney to advise you to make sure you're hitting all of the statutory requirements in the governing law. And the whole process wraps up with a trustee sale rather than a process through the court system. So that is the basic process and my thoughts on the benefits of it. If you are, this is something that we help our lender clients with, both financial institutions or hard money lenders. It's also something that we help our individual clients with if you're faced with a foreclosure. So if you have any questions about the non-judicial foreclosure process, either it's a process you might want to employ or it's a process that you're being subjected to as a borrower, please feel free to reach out. You can give me a call at 425-776-4100, or you can email me at toddc@beresfordlaw.com, and I'd be happy to speak to you about your issues. That's it for today. I thank you for joining me, and we'll see you next time.